please be seated. We are to our third case of the oral argument calendar, Guardian Care Services of Brevard versus Agency for Healthcare Administration. Is the appellant prepared to go for it?
Yes, sir.
Please proceed. And before you start, counsel, if you can kind of tell me how much time you'd like to save for rebuttal.
I'd like to reserve 5 minutes.
Please proceed.
Yes, good morning, and may it please the court. My name is John Terrell, and I represent Guardian Care Services of Brevard, Inc. in this matter. As outlined in the briefs, I think this is basically a plain reading of the statute, along with basically what I'm seeing as Part 2 of the Ybor Medical Center that we dealt with last year in front of the Supreme Court, Florida Supreme Court. What we have here is there's a confusion by ACA between the existing license and the new application. And when you look at the clear language of the statute, the applicant had to prove accreditation within 120 days of filing their application with their agency.
Application, correct?
Sorry?
Within 120 days of their initial application, correct?
Yes, well, this one was a renewal application, but as pointed out in 408-808, these licenses expire every 2 years. So you're starting over again. And that's what the Florida Supreme Court looked at. And they made it pretty clear that when we were dealing with this last year in front of the Florida Supreme Court, that ACA considers a facility's application of fitness for a new license. The existing license is not the subject of a renewal license application. So they made that pretty clear when we were arguing in front of them last year. And that's what Guardian has done. They obtained their accreditation, they maintained it, and carried forward. So that's a pretty clear directive under the statute and by the Florida Supreme Court.
Isn't the key issue in the case that Guardian didn't maintain the accreditation?
That's for the existing license or the prior license. And that is different, and the Supreme Court differentiated between that. They said the prior license was the one that existed before this new application was filed. And when the new application is filed, like it says in the statute, you must prove your accreditation within 120 days, which Guardian did. So basically what they're trying to do is argue something that occurred for a prior license. And if you're going to do that, that's a disciplinary action. And practitioners that have dealt with these kind of cases, like Judge Harvey has, know that this is not what happens. You don't take an action for a prior license period and try and use it on your renewal license or the initial license period. And Dubin, the Dubin case that I cited, clarifies that. It says that, look, this agency just misconstrued and failed to follow what they're supposed to. And when you look at the statute and the recent Ybor medical case, I mean, that's what they're supposed to do, is look at the new application, apply the rules and standards, and they just did not. And this is a fundamental error. This is not just a procedural error. They argued harmless error in their answer brief. This isn't a harmless error. This is a fundamental error that deprived my client of their license and livelihood. I think that basically sums it up for now. I think I'll save the rest of my time for rebuttal. Because again, I think this is a pretty clear case. And as I see it, we both handled this last year in the Florida Supreme Court. They told us how we were to look at these statutes. Guardian has complied with how the statutes are done and how the licensing is done. Thank you.
May it please the court, my name is Tracy George and I represent the Agency for Healthcare Administration, or AHCA, in this case. Resolution of this case is dictated by the black letter law, which provides that in deciding whether to grant or deny a licensure renewal application, AHCA may consider past violations of law in making that decision, and also provides that the failure of the home health agency that provides skilled services to continuously maintain licensure is a violation of law, is a violation of basic licensure requirements.
Can you address the proposition that where the statute says you have the ability, you have the discretion to deny a renewal license based upon past violation of the law, that there hasn't been an adjudication of that past violation? To appellant's point, that there
Duba
hasn't been
case.
administrative action.
Yeah, so under some licensure schemes, that may be true. That's not true under this licensure scheme. Because if you look at the statutes, for instance, 408-813, 408-815, 400, 474, ACA has a choice. We can choose to go after the existing license. But here, where we've got an application, it's only a 2-year license, the application's coming up, we're being told constantly they're going to get the accreditation, they're going to get the accreditation. You know, we decided when the application came through, we had to make a decision on it, we're going to deny it because they didn't continuously maintain the accreditation.
I guess my point though is, yes, they didn't have the accreditation, so they were in violation of the statute that says they were required to maintain accreditation, but they didn't have any adjudication about that. You knew it, it's a matter of fact, it's before you, but because you didn't have an administrative action, you don't have any legal determination that they were without that accreditation.
I would disagree, Your Honor, because there was an adjudication in this case that there was no continuous accreditation, right? Because the legislature said, and if you look at the Osborne case, if you look at the Davis case, there are situations where you can have a licensure renewal application, an initial application, where you do have the choice, right? You have the choice which one you're going to go after. Here, the agency did have the choice, and we proved it by preponderance of the evidence, actually admitted in response to the notice of intent to deny and then in the actual hearing, that they didn't maintain accreditation continuously during the period of the license, and so they weren't allowed. We decided that they should not have licensure again for the next period, keeping in mind that all they have to do is file a new initial application with all the additional stuff that an initial application includes, which is like proof of financial ability to operate, things like that, and this won't count against them, right? So. We're here arguing before you over something that is entirely within the control of the applicant, the loss of accreditation, the type of licensure application that they filed. The license statute clearly says 408-8151C, in addition to the grounds provided in authorizing statutes, grounds that may be used by the agency for denying or revoking a license include any of the following actions by a controlling interest, including a violation of this part authorizing statutes, which would include 400 Part 3, or applicable rules. Logically, the statutory language must refer to violations that have occurred in the past or during the current licensure period, because you can't have violated something in the future for a future period, right? So it has to be talking about violations that occurred during the existing licensure period or during the period before. So it was totally proper for ACA to consider that in denying the licensure renewal application here. There's nothing at all in the statutory scheme that says the agency has to file an AC first. The failure of a home health agency that provides skilled services to continuously maintain accreditation is a violation of the law of the minimum licensure requirements that the legislature has mandated. And the reason for this, it's not completely obvious, but if you think about it, what they're doing, an accrediting body does, is they go out to the facilities and they survey instead of the agency doing it. They're going out there, they're making sure everybody's doing what they're supposed to be doing. It's only for skilled services.
I want to try and read my analogy a little bit here, so help me out. Let's say that there was some other violation other than the accreditation. They had some material violation that normally you would file an AC. Would you be allowed the discretion of the agency to consider that in the renewal licensure process?
Yes,
Even
Your Honor.
though you had not filed the administrative complaint. If there was some sort of gross negligence on their part or something like that, something more substantial.
Yes, Your Honor, we would, as long as we can prove it by the preponderance of the evidence that we do.
During the licensing.
During the licensing period. Now, a lot of times you'll see we do both at the same time, and I know you've seen this. We'll file an action to either impose a fine or revoke an existing license, and then, because the renewal application's before us, we'll also deny the renewal application. Or we'll put conditions on the renewal on the actual renewal license, right? So we can do that in the same hearing. Of course, there's different standards of proof for those two things, preponderance of the evidence for the application and clear and convincing evidence for the other violation. But we're allowed to do that. And again, here, they've admitted that they were unaccredited for an entire year of the 2-year period, right? That's a major violation. That means they've had very little oversight, aside from when I could go out there and survey them in the stead of the accrediting organization during that 1-year period. And keep in mind, this is 2020, okay? So, this to us, this was a big violation. Not only that, the legislature has said it's a mandatory requirement that you can maintain your license. So this isn't a small violation. None of the cases that appellants cited are applicable. We agree that the application for a license for a future period is different than the existing licensure period. That's what we argued in the court, right? And the Supreme Court agreed with us. But the past licensure periods do bear on the fitness of a licensure applicant. I mean, we all know that if you do something bad, it kind of follows you, right? We also know Dubin was decided under old versions of the APA before Osborne and Stern, before in any of the current case law. It's a different licensure scheme. Under that scheme, it was a situation where there was a license that was a ministerial duty to issue, which is not the case here. We've got a lot of discretion. And the Blue Lagoon case, totally inapplicable because it's a different licensure type, and ACCA doesn't claim by statute that any of our statutes mandate denial here. We know it's discretionary. Does the court have any additional questions? And the agency will rest on our briefs. We ask that you affirm.
Thank you. Just a few points here. Again, ACCA is ignoring the plain language of the statute. 400.471 tells what the new applicant must do. Apply for a license, it has to be received by the department, then obtain the accreditation within 120 days. Guardian Care Services did that. That's what they should be concentrating on. Instead, they're concentrating on something that is a disciplinary matter, which has not been adjudicated. There's been no administrative complaint. Now that's ACCA's choice. They can file an administrative complaint or not file it. However, they can't use and ignore this plain language of the statute. And they keep talking about a gap. Well, the gap is right there in the statute. It says, file your application within 120 days after the date of the agency's receipt of the application for licensure. Prove it. Prove that you have it. And they did that.
Is it your client's position that the agency is not permitted by statute to consider a willful violation by Guardian, and even if you dispute this was not willful, let's hypothetically assume it was willful, they are not permitted by statute to consider a willful violation that persisted for a year in determining whether or not to renew the license?
I think that an agency, and any agency, has a bunch of tools in its toolbox, and they use them appropriately. A denial of a new license application under this clear language in the Newport case is not the tool. It's an administrative complaint.
So that argument suggests they didn't exercise their discretion appropriately. Am I hearing it correctly?
It suggests that there's a way that departments handle these cases. You don't hear of an issue months before the renewal comes out, and you just sit on it and wait for the renewal application to come in and then try and do something. That's not how the process works, particularly in this clear language.
And if you answered, I missed it. So is it your position that the statute prohibits the agency from considering past willful violations during the immediately preceding licensure period or the existing licensure period in determining whether to renew the license? Did I ask a poor question? Do I need to restate it? I may need to restate it.
No, I don't think the agency is going to ignore it. I think they're going to use the other tools in their toolbox.
Are they legally prohibited? Does the statute prohibit them from considering that and determining to reject or deny the renewal of the license?
And this is under the hypothetical of a willful violation.
Yes.
I think they can consider it, but I think, again, I don't know that this case deals with the willful violation, so I need more.
So if they take, is it willful? Is this violation willful?
No,
So the not paying the fees to the agent or the entity and allowing it to persist for a year, is the duration of time relevant to determination of whether it's willful?
no, because if you look at the facts that occurred during this, they did pay. And the Joint Commission, which is, again, these are accredited agencies that act on behalf of HALCO with not a lot of oversight. They accepted the payment. So the payment was made, and it was made a while ago. It was made, I think they made a demand in October. They cashed the check by December, mid or early December. So we're not talking a year. We're talking, a little bit after the payment was due. Then what the Joint Commission chose to do, acting on behalf of ACA, is say, no, we don't care. We don't care that you passed the surveys. We don't care that you passed the ACA survey on 12/22/20. We don't care that you're proving that you can provide safe services to these people. And we don't care that you made a payment. We're going to say you're not accredited. Is that a fair outcome of this case? I don't think so. I mean, and when we look at these accrediting organizations, I mean, nothing was done by ACA about this, nothing. They just said, they can do whatever they want. I hope this board doesn't feel the same. So, thank you. If there's any other questions?
Thank you.
Thank you.